Good afternoon, everyone.
Good afternoon.
Good afternoon, Your Honor.
Good afternoon.
Good afternoon, Judge. Whenever you're ready, you can start in courtroom 3.
All right, good afternoon. Let me see if I can see some more faces and then we'll get started.
Hey, Judge Missy, the SAP dated 7/7.
7-7, okay.
Yes, ma'am.
How are you?
I'm good, thanks.
From the state, you got Duncan and Harmon. So
Okay, how are you pre-trial? Did you send me something?
I did.
Oh, let's see. Hold on a second, let me. Last time I looked, I didn't see it, so I apologize for
10 minutes ago.
that. All right. Very short.
Judge, I'm sorry, it's gonna be 7:30.
Uh-oh.
6:30. 6:30, June the 30th.
Okay, 6:30.
Who's in courtroom 3 so I can pull the file?
Position number 2.
All right, good afternoon, ladies and gentlemen. Don't see my ASGs on.
Good afternoon, Your Honor.
There we go. Okay, there they are. All right, nice to see you all, ladies. And hey, Ms. Hogue, how are you? Does Ms. Hogue and Ms. Kim?
Yes, Your Honor.
Okay.
Your Honor, I'm here.
Okay, good, thank you. All right, good afternoon, ladies and gentlemen. My name is Judge Regina Mincy, and we're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and these cases have been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we are able to address matters such as bond, possible arraignment, and consideration of a possible plea offer if one has been made at this juncture. I'll also be providing a reset date for the SAP calendar, which is June 30th. SAP reset date is June 30th. I'm going to begin by letting everyone know that this entire proceeding is being recorded as well as live streamed on YouTube. Govern yourselves accordingly with that. You also, the defendants on this calendar, I want to remind you that you have the constitutional right to have an attorney representing you at this hearing. And most of you obviously have attorneys. If you have a private attorney, I will find that out as we go. I also want to let you know that you have a constitutional right to remain silent. Anything that you say about the facts, the circumstances, and the occurrences regarding your case, remember that the solicitor is here and listening. So defer to your attorneys and try not to say anything that may jeopardize your case later down the road. All right, so we're going to start in South Annex.
Courtroom 3, number 2.
Oh, wait, courtroom 3, number 2. I'm sorry. All right, courtroom 3, position 2 has a great first name. That's Regina Curry.
Hey, how you doing, Judge?
Morning, 22CR003859C. Criminal trespass, 1 count, and the offense date is June 16, 2022. What do you have pre-trial?
19 total. Last arrest was in April for criminal trespass on Marta. She has an open case in state court for trespass and fair evasion. 22CR002 293C. Got an August 2021 Marta arrest, 2 counts of terroristic threats. Those are convictions. 1 count trespass conviction. July 2021 Marta, criminal trespass, and another charge I don't like me to call out.
Okay.
December 2020 probation violation for cruelty in the first and battery family violence. Another 2020 probation violation, 2020 simple assault, 2020 trespass, 2019 shoplifting conviction. You want more?
Nope, that's good. Miss Grace, make sure I'm recording, please. I think I am. Okay. I just got a
Will
message
do.
that it wasn't. Okay. I
Okay,
think it is now. Thank you. All right. This is Miss Brown's case.
Yes, Judge.
All right, Go
This,
ahead.
this case happened on June 16th. Basically, Mrs. Curry was found at the 5 Points MARTA station at 30 Alabama Road after 5 Points MARTA station at 30 Alabama Road after having been given a 365-day MARTA suspension. As you heard from pretrial, she has just recently received a criminal trespass arrest. I believe she has about 2 others in her record, in addition to 3 VOPs and a number of convictions, Judge. At this point, she's definitely a risk to reoffend. It's apparent that she's not going to abide by these MARTA suspensions. And so at this point, Judge, our recommendation is to leave the bond as it is. She currently has a 500 surety, and we just ask that that bond remain the same.
All right, Miss Hogue.
Yes, Your Honor. Ms. Curry is 31 years old, Your Honor, and she is a lifetime resident of Atlanta, not just Georgia, but Atlanta. She has brothers, sisters here, as well as children. I've verified too that she has an address on Jonesboro Road where she does live and can receive mail. She is a high school graduate through Job Corps and actually got trained as a brickmaker of all things through Job Corps, though she's not actually utilized that particular skill. She's done more retail type cashiering jobs since high school. She has obviously limited income. I did speak with her about this and asked her if she understood that the MARTA ban or suspension was for a full 365 days. She said she did not understand. She thought it was only for a month. I did explain to her that it is for 365 days. So if the court could see their way to making this a signature bond, I have informed her that if she comes back on there for at least a year, she's banned and she cannot go on MARTA for at least a year. That she says she now truly understands that the ban is for a full year, not just for a month. So if the court could see their way to taking it to a signature bond, because she's right now in between jobs, so she is financially stressed, and it would be very hard for her to make that, we would greatly appreciate it.
All right. I heard a lot of other, she's got an open case right now with MARTA as well. Is that correct?
I believe that is correct, Judge. And so I think that's indicative of the fact that she probably does understand these suspensions and just is intent on disregarding them.
Ms. Curry, you're going to have to find another means of transportation, or Uber, Lyft, and the other ride shares. You understand that?
Yes, ma'am.
You cannot go back to MARTA.
Okay.
All right, I'm going to grant a signature bond through the jail for the $1,000. It's $1,000 signature bond through the jail. I'm going to again order that you stay away from all MARTA. You don't even go by the stations. Don't even be near there, or else you'll be rearrested. No drugs, alcohol, or weapons while on bond. And I think that should conclude this case. Is anything else I need to take up?
Nothing from the defense, Your Honor.
Nothing from the state, Judge.
All right,
Thank
thank you.
you. Speaker, see where on the first one. Okay. Position number 8 is next, please.
Okay. This is case number 22 CR 0038648H. Alicia McPherson. You're charged with 1 count of driving improper erratic lane change, 2nd count of criminal trespass and damage to property, and a 3rd count of simple battery, all with the offense date of June 16, 2022. Pre-trial.
She got 9 total. She got history out of Nevada, Louisiana, Tennessee, Wisconsin, and Illinois. 2019 Nevada domestic battery. 2018 Louisiana disturbing the peace battery. Let's see what we got here. 2021 Tennessee public intoxication and resisting arrest. That was a conviction. 2020 Illinois resisting peace officer, no driver's license, no insurance. Says operator under suspension. 2021 out of Milwaukee, reckless driving causing bodily harm. 2020 reckless driving causing bodily harm, hit and run. The first one was a juvie. Last arrest in Georgia was a Walton County 2020, driving without a valid license. She got PTI before it was dismissed. That's it.
Okay. All right, Ms. Harmon.
Yes, Your Honor. This incident occurred at the second part of it occurred at 165 Ivan Allen Boulevard, Northwest. The first part of the incident occurred on 7585 southbound before the William Street exit. The parties in this case, who is the defendant and the victim, Alexis Joyner, Joiner, they collided in an accident on the highway, and it's alleged that the defendant moved from the 4th travel lane to the 3rd travel lane and struck the rear side of the victim's bumper. The defendant said that to officers that she thought that the victim was trying to flee the scene, so she followed her off the highway. The victim maintains that she was just trying to find a safe place to pull over. When she arrived at the incident location on Ivan Allen, the defendant immediately got out of her car and rushed the victim and pinned her to the vehicle. The defendant told the victim that she was going to beat her ass, and then she kicked her vehicle multiple times and keyed the card. There were staff from the Atlanta Mission, which is that incident location, that did witness the pinning and the keying of the car. We absolutely believe that this defendant is a danger to the victim based on the incident details. Based off her history, we do believe that she's at a risk to reoffend. She does have speeding convictions, reckless driving convictions. There's also a domestic battery arrest in Nevada out of 2021 and a battery arrest out of Louisiana in 2018. Your Honor, it's also very concerning that she has history out of, I think, at least 5 states at this point. So we do believe that she does present some risk of flight. In light of the foregoing, Your Honor, we are recommending a bond for the erratic lane change, 1,500 surety bond. For the criminal damage to property, 1,000 surety bond. For the simple battery, 1,500 surety bond, for a total of a 4,000 surety bond. Stay away from the incident location in front of the Atlanta Mission, and no further contact with the victim, in this case, Alexis Joyner. Nothing further.
All right, Ms. Kim.
Yes, Your Honor. Miss Alicia McPherson is 22 years old, and she has been here in Georgia for the last 2 years. She moved here 2020, and as a certified nurse technician, what she does is that she takes blood from the different patients who need her service. We would like to request for signature on bond, as she does not have there was no intent to commit any violence. She just threw the car to the lady who she thought was going to harm her. So she did not want to have any contact. That's why she kind of threw the key to the person. And then that was kind of shown as it was kind of misunderstood, I guess. So we would like to request for signature on bond for that. For if your honor is not inclined to give him a signature on bond, we would like to request for the maximum $1,000 surety bond, your honor. Thank you.
And Your Honor, excuse me, the violence being alleged in this case is when the defendant allegedly pinned the victim to the vehicle. The throwing of the keys and the keying of the car and the pinning was all witnessed by third parties that were outside of the Atlanta mission. So that, that's the basis of the charge.
Okay. All right, I'm going to enter the $4,000 surety bond. That's $1,500 on the first charge, the erratic lane change, $1,000 on the criminal trespass, and $1,500 rather on the simple battery, for a total of $4,000. I am going to order that there be no further contact with the victim, Alexis Joyner. And as far as the stay away from this Ivan Island address, I'm not sure that I need to, because again, it sounds like it's just somewhere where they pulled over.
Yes, your honor.
And so I'm not going to order a stay away, but certainly no further contact with the victim. No drugs, alcohol, or weapons while on bond. And I was going to say, but I don't know that I see this on the driver's license or if they're suspended or not. But just make sure, Ms. McPherson, that you have a valid driver's license if you start to drive, if you get out on bond.
Your honor, about the contacting the victim only for auto accident related issues, shall she go through the law enforcement officer to contact them? Yes.
Oh, if she needs it to process the claim?
Yes. Your honor.
Yes, go through law enforcement.
Okay.
Do not call the victim about that. I mean,
No problem, your honor.
insurance is handling it, but hopefully they can handle it without her having to talk to them.
Okay. Thank you, your honor.
All right, that concludes this case.
That was 4,000 good?
Yes.
Whenever you're ready, Your Honor, we got position number 6, Mr. Lowe.
Okay. This is case number 22 CR 003860C. Mr. Billy Lowe. There's one count of public drunk. Second count, possession and use of drug-related objects. Third count of willful obstruction of a law enforcement officer. All three charges with the offense date of June 16, 2022. You have anything pretrial?
47 total. Last arrest was, let's see, 2019 probation violation for CWAC. 2019 misdemeanor obstruction conviction out of Baldwin County. 2019 probation violation. 2019 possession of a Schedule 1 or 2 controlled substance. Crossing state county guard lines with drugs, weapons, possession of drug-related objects. 2018 probation violation, another 2018 probation violation. He's on felony probation in Baldwin County for obstruction. This came from a 2018 case. 2018 simple battery, that was dismissed. 2018, you got more probation violations. You want, that's enough?
Yes, that's good. Thank you. Ms. Duncan?
Yes, Your Honor. This incident took place yesterday on Ralph David Abernathy Boulevard. In this case, the defendant was seen drinking from an Old English 800, which is an alcoholic beverage. And when confronted by officers, and he began to talk loudly and use profanity, such to the point that it started to cause a disturbance in the area. And I might note for the record that all of this took place at about between 2:42 and 3 a.m. in the morning. We have a concern of this defendant being a risk of reoffense due to the fact that this defendant does have 2 previous convictions for willful obstruction as well as arrest for possession of drug-related objects. And in this case, he was witnessed by officers publicly drinking. There is a preset bond in this case, Your Honor, of $2,000 total surety. The state is going to ask that that remain the same, and the breakdown for that is $500 surety for the public drunk, $500 for the possession, and $1,000 surety for the willful obstruction. In addition, the state would ask that there be no further violent contact with the officers in this case. And as far as the obstruction, my apologies. When apprehended, this defendant began to kick the inside of the patrol car window in an attempt to damage it. That's the basis for the obstruction. I'm going back to the recommendation. We would ask for no alcohol, drugs, and weapons. And we would also ask that this defendant be subject to random screens and no further violations of Georgia law.
Okay.
Yes, Your Honor. Mr. Lowe is 50 years old and he has been here in Georgia for all his life. He has 3 adult children and his mother is 84 years old. He's been working through temporary services here and on and off odd jobs. Right now, he does not have any financial means to pay for a surety bond. We would like to request, actually, he was in jail for about 2 years and in Baldwin County, and he recently got out of the jail. We would like to request for signature on bond, and yet if Your Honor is not inclined to give him a signature on bond, we would like to request for $1,000 maximum, $250 for public drinking, $250 for possession of drug, and $500 officer obstruction. Thank you, Your Honor.
Okay. And did you tell me whether or not, or repeat that, does Mr. Lowe work or?
He gets job through the temporary services, but it's not consistent, Your Honor.
Okay. All right, I'm going to award a surety bond, $2,000. On the first charge, 500, which is public drunk. Second charge, 500, possession and use of drug related objects, and the willful obstruction, 1,000. So that should equal to 2,000. No drugs, alcohol, or weapons while on bond. And no further violent contact with the officer.
Yes.
Okay. You have the last name by chance?
The officer in this case is,
Just his last name?
1 second, I can get that for you.
Okay.
This is Lowe, correct?
Yes.
I believe this officer was James Young.
Okay.
I mean, Officer Young.
Yeah. Okay. All right. So no further violent contact with Officer Young, and no drugs, alcohol, or weapons while on bond. I don't have, and I don't think there was a request for a stay away at all.
No, Your Honor.
Okay. All right, then that should conclude this matter.
Thank you.
Position 11, Robinson.
Your Honor, before we begin, my apologies. I want to correct the record. That officer for the last case is Smith.
Oh, Officer Smith. Okay. You have that, Ms. Grace?
Yes, thank.
All right, thank you. This is case number 22 CR 003867C. Richard Robinson, you're charged with 1 count of simple battery, family violence. The offense date is June 16, 2022. Pre-trial?
I got 4 total. Last arrest was June 30th, 2021. Battery DV, simple battery DV, cruelty in the third, criminal trespass. I think that was the same victim, if I'm not mistaken. So he got 2 open cases in state court. One of them is 21 CR 003 120C as in cat, 21 CR 003 122C. I think that's it. He had an 02 arrest in Florida for violence, but it was dismissed. That's it.
Okay.
Hello?
All right, Ms. Harmon?
Yes, Your Honor. The incident location in this case is 516 Wolfpack Lane in the city of South Fulton. And the victim, her name is Leisha Warlock, Lesha, last name Warlock, Warlock. The parties share 1 child and they live together. The victim advised officers in this case that the defendant wanted to talk and she refused. She locked herself in her child's room, and then the defendant took it upon himself to kick in the door and grab her by the t-shirt. Additionally, he struck her in the face with his elbow, and a child was present while this was going on, Your Honor. There weren't any visible injuries, and the defendant in this case all out denied that a physical altercation took place. We did speak to the victim in this case, Your Honor, and she said that this is not the first time that violence has occurred. Mr. Howard is correct in those cases that he recited to you. She is in fact the victim in both of those open cases in state court. She advised our office that they're no longer in a relationship, but they do, however, live together and they share a child. She says she's in the process of moving out and she needs time to get her things. She wants the defendant to stay away from the residence until she can leave. She did tell us this is not the first time it's happened and the violence has gone on too long and she's exhausted. She would ask the court to order the defendant to have no contact with the victim. And she would ask the court would order a third-party transfer of the child and a one-time law enforcement escort so he can get his belongings. However, Your Honor, going back to that April 21st, April of 2021 battery family violence, the brief facts are in that case is that the defendant is accused of grabbing the victim by the neck and pushing her into a kitchen cabinet. He got a $1,500 surety bond, a stay away from the incident location, a no further contact with the victim or the children until they were legitimated, no alcohol, drugs, or weapons, and Judge Law ordered that. On the June of 2021 incident, he's accused of punching the victim in the back multiple times, and Judge Law ordered the same conditions on his bond and gave him a $7,000 good bond. In light of the foregoing, in light of the fact that he is a clear risk to reoffend, he's a clear danger to this victim, we would ask that you order a $10,000 cash only bond, no further contact with the victim, Leisha Warlock, to stay away from the incident location, 1-day anger awareness course, no alcohol, drugs, or weapons, no further contact with the children unless legitimated as Judge Law already ordered. And Your Honor, we're asking this bond to be set as such because again, he has consistently shown us and he has shown the court that he has no problem putting his hands on this woman and hitting her, and he does not respect the orders of the court. He's been ordered twice now by Judge Law to stay away from the incident location and the victim, and he has returned yet again and committed yet another act of violence upon her. So we would ask that you would follow our bond recommendation in this case. Nothing further.
Okay.
And Your Honor, again, I'm just so she's not overlooked. She may be on the Zoom, but I don't necessarily see her name, but she can, so if you can sound for her.
All right. Is Miss Warlock on the line? Is Miss Warlock in the Zoom format here? Miss Warlock. All right, since we don't have the victim, Miss Warlock, we'll move on. I'm
Yeah.
going to,
May I please?
oh, I'm sorry, Miss Kim, didn't mean to forget you, I'm sorry. Go ahead, Miss
Yeah.
Kim.
Yes, Your Honor, Mr. Robinson is 44 years old, and the house that they're residing together is actually, it belongs to Mr. Robinson. It is him who owns the house, and he's been politely asking Ms. Michelle Wallow to move out. And please, it has been really, really long time, and I believe that she has to go to the shelter for the victims of domestic violence. I don't think she should be there anymore. Please ask her to move. And until then, I'm sure that my client is not opposing the stay away until she finds the place to move out really fast. And they do have one child together who is 2 years old. However, he also has other children as well. He has a strong ties to the community. He's been here in Georgia ever since 2007. So, and he also has a job that he has been working for last 12 years. And he has a bachelor's degree, and he is working as a nurse. And we would like to request for very low surety bond. We do understand that even though I want to ask for signature on bond because of the fact that we do have 2 open cases, we would like to request for $1,000 surety bond, Your Honor. Thank you. Not the cash bond. $10,000 surety bond is much better than cash bond, Your Honor. Thank you.
And of course, Your Honor, we would ask that you would keep it as that you would follow our recommendations. And further, Your Honor, I just want to say for the record, she is the victim. She stated that she was trying to move and she would like for him to not be there while she's moved. But because she is the victim, she shouldn't have to move. She lives there. He should have to stay away from that residence. So I would ask you to order it in a way that she can stay there. And if she moves, he can return. But I'm not asking the court to order her to move.
Your Honor, this house, the deed belong to him. He's the only one who owns. He's the only one who has paid every single mortgage payment, Your Honor, and utility bills and every expenses that's involved in the house.
Okay. I'm going to order a $10,000 surety bond. And I'm going to order to stay away from the incident location, 516, is it Wolfpack Lane?
Yes.
I'm going to order no further contact with the victim, Leisha Warlock. I'm going to order a one-day anger awareness course. And no drugs, alcohol, or weapons while on bond.
Your Honor, may he please have a one-time visit with a law enforcement officer for personal belongings? And also, when he evicts her with a court order, since she is the tenant, can he return to his place, Your Honor?
What I'll put in there, and Ms. Grace catch this for me, is that he will get a one-time police escort back to the property location on Wolfpack to retrieve his personal belongings. If he get there with the officer and finds out that all of Miss Warlock's items are gone and it appears that she does not have any belongings there, nor lives there, then he can stay there. But I suggest you look around and have the officer to see that there are no woman's belongings there for Miss Warlock. And then that would be the verification, would be the officer doing that sweep or look around to determine that she doesn't reside there anymore. Doesn't have any items there to imply that she resides there.
And Your Honor, as far as the children are concerned, I didn't hear your condition on that.
Oh yeah, third party person to exchange children if visitation is allowed by Miss Warlock. To have third party exchange so that he doesn't violate by contacting Miss Warlock. She'll tell you, I guess, who that third person is, and that's who you need to coordinate with any with that person for any visitation. All right, anything else that I need to take up with either council?
What about the cruelty to children? Was that dismissed?
Yes,
Okay, I didn't have that one on, just the one charge.
You said yes, it was dismissed?
yes, correct.
Okay, thank you.
Next
All
one,
right.
number 4, Mr. Gomez.
'22 CR 003865D. Mr. Stephen Gomez, you're charged with 1 count of simple battery against a police officer or detention officer. That offense date is June 14th, 2022. What do you have pretrial?
I see 26 cycles. He's been in jail since last year. Aggravated assault with a deadly weapon. And he got some other charges, felony charges as well. I got a 2020 out of, I guess it's Massachusetts. It says AB with dangerous weapon. 2019, same thing. 2017, same thing. 2009 armed assault with intent to murder. Yeah, so that's about it. But he got some open felony stuff
Okay,
with no bond.
all right, Ms. Duncan.
Yes, Your Honor. In this incident, the state has a very large concern for the risk of reoffending and the fact that we have a concern about this defendant being a continued danger to the community. In this case specifically, this defendant is cited as having thrown a mixture of urine and feces out of his cell while the cell door was open. That mixture was did in fact land on an officer, Officer Skyers. That is the basis for this warrant. Additionally, Your Honor, this defendant, under this current booking, since he's been incarcerated for over 500 days, does have another simple battery against a police officer or detention officer from 2021. And we would just like to note for the record that this is an ongoing investigation and the state may seek to upgrade or add additional charges as more information becomes available. But given this defendant's criminal history, and history with similar offenses, we are going to request that the bond remain as it is previously preset at $3,000 surety, that this defendant have no further violent contact with this officer Skyers, no alcohol, drugs, or weapons, and no new violations of Georgia law.
All right. Ms. Hogue.
Yes, Your Honor. And speaking with Mr. Gomez has wished to be pro se today. And so I did admonish or warn him about speaking in anything that could be incriminating. I'm sure the court will do the same thing, but he is requested to be pro se today.
Okay. All right, Mr. Gomez.
How are you, ma'am? Good morning. Good afternoon.
Good afternoon. So you want to represent yourself?
Yes, ma'am. I would like to represent myself and I would like to argue my bond today.
Okay, and the consequences of that, correct? Need to know the rules of law as it goes.
Yes, ma'am.
All right, go ahead.
I want to present one thing that I want to start off by saying that I'm in danger of my well-being and my safety as an inmate being in the custody of the Fulton County Sheriff Department. As I've been here for at least 500 days in the Fulton County Sheriff Department, I want to just start off by saying that I'm going through a lot of abuse allegations, and I've been reporting them a lot, and I've been being ignored by the Fulton County Sheriff Department. Also, I've been ignored by a lot of the Fulton County officers at the courthouse, that I've been reporting that I've been abused and that I'm in danger to my well-being by the Fulton County Sheriff Department on me. I just want to start off by saying that. And I want to start off by saying one thing. I want to start off by arguing my bond today to say that it's a habeas corpus writ. I filed a motion for a habeas corpus writ, and this was probably about, the date says, I'm going to give you the docket number. The date says 5/25/2022, and it says Stephen James Gomez Jr. versus Fulton County Sheriff. I'm going to give the docket number on this. This is me arguing my bond. It's the docket.
Your Honor.
This is me arguing my bond. This is a habeas corpus writ, and the habeas corpus.
This is not that forum for this. You would have to do the proper motion for that, Mr. Gomez. It is just the factors that I'm considering in order to set your bond amount.
I just wanted to present the fact that I did make an attempt to file a habeas corpus writ to just present that I was going through. I made an attempt to report that I was under an allegation, that I needed to report to the state that there was an incident with my well-being. I just wanted to say that I did file a habeas corpus, man. And I was basically just stating that it was denied, not only off the fact that the jail system did not allow me to do the proper filing fee. They did not allow me to file my improprious petition. They were not allowing me to basically file my account statement to the court system. So they denied it, not because it was denied off any of my allegations, but the jail system would not give me a proper authority of an officer to present my account statement. So it was closed. I was not allowed to even file that to present that. Let me just say this. I'll leave that there, and then I'll just move on to this, Your Honor. I'll move right on to this. Okay, and we're gonna go right into that. My name is Stephen James Gomez. 33 years old. I'm originally from Boston, Massachusetts. I am a college graduate. I went to Berkeley College School in Manhattan, professional studies. I do have a high school diploma, yes, and I am basically down here in Atlanta, Georgia for aggravated assault with a deadly weapon. And basically that case was back in last January 2020. I'm still being basically tried for that case right now. There's never been any victim, never been any evidence on that case ever. So I'm basically just being held. I've sat in the court systems in Fulton County since that time of, I think it was January 19, 2021 was my first day in the jail. And for the original case.
Again, objection, Your Honor.
Yeah. All right, Mr. Gomez. In the essence of time, I do get the gist of what you're saying.
I wasn't even able to even argue my bail.
Okay.
My bond, I haven't even been able to get to that. I'm trying to argue my bail, Your Honor. Is there any way I can do that? I'm sorry. Because I didn't
need you to move it along a little bit. You're getting into some areas that I cannot address today.
All right. I want to say this. As far as that situation happened, the officer in that incident was Officer Schuyler. I want to start off by saying the officer ended up cutting off from my water valve. The officer came into the unit that I'm in administrative lockdown, and he went upstairs and he cut off my water in my room. So I had no active water in my sink or in my toilet. And there was a nurse named Florence that was actually distributing medication at the time. And at the same time that the incident even took place, I was getting medication from a nurse. This same officer took a can of spray, an OC chemical spray out of his belt. And when the door opened up, was attempting to have a nurse named Florence at the Fulton County Jail say, Mr. Gomez, do you want your medication? I would have stuck my hand out or my face out to get my medicine. And the officer in this incident had a can of spray, chemical OC, and was attempting to spray me in my face and burn my face and my entire body with that chemical, and then shut the door on. Now I'm in cell 14 in this zone called 7 North, zone 100. I'm in cell 14. And cell 15, this same officer right before that had actually went to cell 15 with that same nurse, and the nurse gave the inmate in cell 15, do you want your medication? He said yes. The second he reached out to get his medication, this same officer in this incident sprayed him with chemicals in his face. It's a can of spray, OC, and sprayed him and burned him, and then they closed the flap, and then they moved on to the next door. Now, when they got to cell 14, they opened my door. My cell door opened up, and an officer had a can of spray ready to spray me. He is the same officer that 2 days before that had cut off my water and had cut off my sink water, my toilet and my sink water. And he went and did that for no apparent reason. I did not do anything wrong. I did not challenge that officer. I did not attack that officer. That officer came into that unit and cut off my water at that time.
Okay, tell me this. I'm gonna ask you 3 questions. How old are you?
I'm 33 years old.
Okay, do you work?
Yes, I do work.
Okay.
I work at a place called, I work in Staten Island, New York City. My last previous job that I was working at was at an area called Designer Stone. It's in Staten Island, New York City. I do forklifting for them. That was my last residence. It's my last work employee. It was a place called Designer Stone in Staten Island, New York, and we did forklifting.
When were you last there to work?
The night I was arrested. I was supposed to be at work that morning. I was in New York. I was arrested in New York City. I was supposed to be at work that morning. I never made it. I've been in Atlanta since.
Okay, what date was that?
December 30. I was arrested New Year's. December 31st, 2020. And I was supposed to be to work.
All
I never
right.
made it.
And do you have any family or relatives in Georgia?
Yes, I do have family and relatives in Georgia. Yes, ma'am, I do.
Are you intending to reside in Georgia or not?
I can reside in Georgia. Yes, I can. Yes, I will. If I need to be, yes, I don't have no problem with residing in Georgia. And I don't have no problem with providing information to family or any family contact to the courts that can provide that information and give me a safe place to stay in Atlanta, Georgia. Yes, I don't have any problem with it. I do have phone contact information and everything I can provide to the courts. Yes, ma'am.
All right, what I'm going to do, I'm going to go ahead and order a surety bond. And with that surety bond, it's going to be $3,500, $3,500 surety bond. I'm going to order that if and when you are out on bond, that there be no drugs, alcohol, or weapons while on bond. And I'm going to order no further violent contact. And is it Officer Schuyler?
Skyers, Your Honor. It's
Skyers.
Kyers, according to my records.
Skyers, okay.
And Your Honor, when I say that he's working the same unit that I'm on every day. So how can I ever get away from that? I'm in administrative lockdown and he's working that same entire unit every day. He was here last night.
Right, you're going to have to do that within the auspices of the jail. I just want to make sure that you have no further violent contact with him. And
So if he's working at the time, what am I supposed to do? If he's working the same shift?
Well, he can't have any violent contact with you and you should not have any with him. That is all that I'm able to order at this time. And whatever else you could do within the auspices of the jail, you can try to complete whatever paperwork you need to do for that. But
All right, one last thing I want to say.
order anything further.
There was a fire that was set in cell 15. An inmate in cell 105 in that same unit, when my water was cut off, they set a fire in the jail in cell 15. And that same time my water was cut off, there was a fire set in cell 15.
Maybe that had something
And there was a fire set.
Okay, but I
And
cannot
my water
do
was
anything
cut off.
about that. I understand, but I cannot do anything about that. I'm only here to hear your case regarding your bond and what happened. And I know there may be a lot of other ancillary incidents going on around that, but I am
Listen.
not privy to do anything about that today.
I
But
just
you
want to
do have
note
a
that
35
the same officer had allowed a fire to be set but cut my water off in that
Okay.
same unit. And what am I supposed to do?
Yeah,
If
I
that- if
cannot
there was a fire-
advise you. I cannot advise you. You can seek legal counsel, get an attorney to help you with that. But right now, you have a $3,500 surety bond, okay?
So I'm not allowed to do anything if there's another fire set in my room and this same officer has, and I'm reporting to the judge that there was a fire set in that unit.
I cannot address that matter, but there are some things that you can do within the jail or seek some other legal counsel regarding that, okay? There's
And if
nothing that I
if
can
I
do.
noted that the jail does not do anything from this day forward, after we speak today, what else can I do to defend and protect my well safety of my life?
You probably need to get an attorney so that attorney can help you.
I do have an attorney, but if my attorney is not willing to speak for me, what can I say about that?
And you need to get another attorney if that attorney's not willing to speak with you, okay?
And if that attorney is not willing to speak, then what can I go from there?
Keep trying
Because
to
am I not-
find some representation. I'm gonna
So
have to
if
cut
my
you off
state
because I
not
need to move
credible enough.
along. I'm gonna cut you off because I need to move along. You're gonna have to find counsel somewhere.
I just want to say that is my statement not credible enough, me, to be.
I
to
can't
be-
address that. I cannot address that. Contact your family, see if they can help you to find an attorney, okay?
So, all right, go ahead. Yeah, thank you, Your Honor. And my bond is what?
3,500.
And I'm reporting that there was a fire set and the same officers working my entire unit.
Okay,
So where do we
Room
go?
one, come on,
okay, we'll
y'all.
have to move on from that, okay?
Don't worry about it, please.
Your Honor, if you could please restate the bond and the conditions, I didn't get all of it.
$3,500 surety bond, no drugs, alcohol, or weapons while on bond, and no further violent contact with Officer Skyers.
Thank you.
All right, thank you.
Position 5 is next, Kennard.
This is case number 22 CR 003861B. Lee Kennard, you charged with 1 count of lauder prowl. Offense date 6/16/2022. Pre-trial.
46 total. Last arrest was 2020 aggravated assault, false statements or writings, concealing facts or fraudulent documents in matter of government something, possession of tools, terroristic threats. He also has history out of the state of Alabama, just a FYI. Got 2019 probation violation, 2020 parole violation, another 2019 probation, 2017 probation, 2016 probation, possession of meth and cocaine, underlying charge. He was convicted for that in 2016 out of Gwinnett. 2016 FTA for entering auto, theft by taking, and criminal trespass. You want more?
No, that's good. Thank you. Ms. Duncan?
Okay, Your Honor, this incident occurred at 978 9th Street Northeast in Atlanta, which is the residence of the victim, in this case, Claire Sammons. Claire is spelled Claire. Sammons is spelled Sammons. At the time of this incident, Your Honor, it took place around 2:35 in the morning. This defendant, officers were called in response to a prowler. And upon arriving on the scene, officers were met with the victim, in this case, Ms. Sammons, and she notified officers that this particular defendant was banging on her door and ringing her doorbell continuously. She said that she was sleeping and it awoke her from her sleep. And as she approached the door to see what was going on, she saw that this defendant had went and got a broom that belonged to her neighbors next door and was walking back up her driveway. At that time, officers had made it onto scene and they engaged the defendant and told him to stop what he was doing. And initially, upon contact, the defendant began running away from the residence. But when officers approached after telling him to stop a second time, he explained to officers that he was just knocking on the door and bamming and things like that because he was trying to get away from some people that were trying to fight him in the park. However, it is notable to the state that officers indicated that upon the initial interaction telling him to stop, when he took off running, he was actually running towards the park. We are particularly concerned about the safety of this victim and the danger to this victim. The victim indicated to our offices that she does not know this defendant at all. So this seems to be a random engagement on a person's house at 2:35 in the morning. And Your Honor, we are concerned again about the risk of reoffense because there are similar charges in his criminal history. There is a preset bond on this case, but given this defendant's criminal history with entering auto, criminal trespass, and things of the nature, we are requesting a $7,000 surety bond because we have a concern also that this defendant is a danger to the community. He seems to have a pattern of trying to enter places where he does not belong and taking things from people that do not belong to him. We would also ask for no further contact with the victim in this case, a stay away from the incident location, no alcohol, drugs, and weapons, and no further violations of Georgia law. The victim did indicate to our office that she would be on the Zoom call. However, she may not be available to speak, but I don't want her to be passed up if she is available to speak. So I would implore Your Honor to sound for her at this time.
All right. Is Ms. Salmons on the Zoom call? I do see someone signed in under that name. Ms. Salmons, can you hear me? Ms. Salmons. Well, she signed in, but maybe she has walked away.
She indicated that she was working, but I wanted her to have the chance to speak if she was able to. But since she isn't answering, she might not be able to speak, but she did relay to our office that she does not know this defendant and would like him to stay away from her property. Oh, she said that
She said she's here. Okay, I'm seeing it as well. Are you able to unmute yourself and turn on your camera if you want to address the court, Ms. Salmons?
She said that she, well, I
She
think Your
can't
Honor,
unmute. She may be at work. I do take note that she is typing in the chat, and she has put that he actually had a shovel and not a broom. Okay.
so it seems to the state under these circumstances, Your Honor, that the intent may not have been to just get away from someone who was trying to fight him, but rather to enter the property unannounced.
Okay.
And I don't know if I stated it for the record, but I want to make sure the address for this incident is 378 9th Street Northeast in Atlanta.
Okay.
Nothing further from the state.
All right. And is this Ms. Kim's case or Ms. Holt?
I believe this.
Yes, this is my case, Your Honor.
Okay.
In reference to this, Your Honor, I'd like to say, I do understand the facts here as alleged. And my understanding of this is Mr. Kennard, correct, Your Honor? I want to make sure I have yes, I'm pronouncing his name correctly. Your Honor, I understand the facts as alleged here, Your Honor. He is charged with loitering. The marijuana misdemeanor charge has been dismissed. In reading these facts, Your Honor, first off to say that Mr. Kennard has been here for 20 years, since 1995. He has nephews, sisters, nieces, and significant family ties here. He is currently employed at Dugan's on Ponce. There he is hired. He's been working as a cook for 2 months. I understand that this case is, he has a history, Your Honor, and it is loitering and prowling, Your Honor. However, in reading the facts of this, it sounded like he was knocking on the door and ringing the doorbell. And when there was eventually no answer, he did leave the premises. Well, he took a broom and alleged a incident in the park as protection. That is what it was. There was no incident where he was staying there after there was no answer, Your Honor. I do understand, like I said, he has a history and that there is a current request, but we would like to see if he would either be granted either a signature bond given his limited income, his newly job, or at most $1,000 surety bond. Obviously, a stay away is no issue, and we would ask that in the court.
All right. I'm going to order the $2,500 surety bond. I'm going to order stay away from 378 9th Street Northeast. You're not to go to that location Mr. Kennard, or else you'll be arrested again. You are to stay away from the victim, Claire Simmons, no further contact with her. No further contact with Ms. Salmons. No drugs, alcohol, or weapons while on bond. And that should be it, unless council has anything else we need to take up.
Nothing further from the state.
Nothing further from the defense, Your Honor.
All right, thank you.
Thank you.
Position 7, Martin.
This is case number 22 CR 003857A. This is Jeremiah Martin. You're charged with 1 count of possession of false identification documents. The offense date is June 16, 2022.
This is
All
ninth
right.
arrest.
9th arrest, okay.
History out of Missouri and Illinois. I'll start with Missouri first. October 2021, possession of a controlled substance, 2 counts. Appears to be open. October 2019, possession of a controlled substance, 2 counts. 2019, suspended license. I got a stealing from 2019 as well, and possession of a controlled substance. 2017 out of Illinois, violation of bail bond. 2015, suspended license. Last arrest in Georgia was last month in Snellville, suspended license. He had a September 2021 fugitive from justice warrant. That's it.
All right, Ms. Harmon.
Yes, Your Honor. Excuse me. The incident location in this offense is 1217 Metropolitan Parkway in Atlanta. The defendant was a passenger in a vehicle stopped for no insurance. And during the traffic stop, the defendant presented officers with an ID containing his biological information. However, the license returned to a white male with another name. He then gave the officer an ID, a state ID from Illinois with the correct information. Our concern in this case, Your Honor, is that he is a multi-state offender with arrests in multiple states, and that he did present an out-of-state ID to the officer in this case. So we do regard him as a flight risk. And Your Honor, if you give me one moment, I just need to pull one thing. Our recommendation in this case is a $1,500 surety bond. That was already the preset bond in this case, and that is to reflect the fact that he is a flight risk. No driving without a valid license, no alcohol, drugs, or weapons. Nothing further.
Okay.
Your Honor, Mr. Martin is 28 years old, and he has been here in Georgia for the last 3 years. He has 1 child that he has to take care of. He also works as a temporary services, so on and off through the temporary services. He graduated from high school, and he has studied 1.5 years of business accounting at the college. And yet right now his financial situation is not that stable yet. And I just don't understand why he was even asked for the ID. He was a passenger. He was not driving the vehicle. We would like to request for signature on bond, and yet because of the concern that he has other cases from different places, we would like to request for maximum $250 surety bond, Your Honor. Thank you.
Okay. I'm going to keep the bond at the 1,500 surety bond. No drugs, alcohol, or weapons while on bond.
Mr. Martin, please, you have every right to remain silent, and also judge is talking. So we would like to request for you to be silent. Thank you.
All right, no driving without a valid license. Unless you have a valid license, you should not be driving. Stay away from the incident location, 2017 Metropolitan Parkway in Atlanta. And that's all our order at this time.
Your Honor.
Mhm.
Who's next?
May I speak now, Your Honor?
No, your attorney has asked you not to speak and you should not. It could hurt your case. I've already ruled.
May I call you? I'll call you back. I'll call you, Mr. Martin.
Position 9, Mr. Moran.
This is 22 CR 003863E. Mr. Moran Hickey is a hyphenated name. One charge of theft by taking with the misdemeanor. June 15, 2022 is the offense date. Pre-trial.
Fifth arrest, last was 2018 out of Gwinnett, sale of marijuana conviction. 2018 failed to appear, not prosecuted. Got a 2015 shoplifting first offender. Another 2015 shoplifting. He got PTI. It was dismissed after that. That's it.
Okay. Ms. Harmon.
Yes, Your Honor. This incident took place at 9650 Medlock Bridge Road in Johns Creek. According to the warrant, the defendant took $80 from the Waffle House and put it in his pocket, and then he left the premises. Your Honor, I think that he does present a risk to reoffend, even though these are older offenses, with the 2015 theft by shop diverted in the 2016 theft by shoplifting first offender. And I'm also concerned about the FTA from 2018, which of course is more recent. The bond was preset at 1,000 surety, but I'm recommending a $1,500 surety bond in light of the history. Stay away from the incident location, no alcohol, drugs, or weapons, nothing further.
All right, Ms. Kim.
Yes, Your Honor. Give me 1 second, Your Honor. I was getting anyway, Mr. Moran is 24 years old, and he has been here in Georgia for about 20 years. He has his parents and sisters all here in Georgia. He's not a flight risk, and he's recommended by pretrial services for a signature on bond. So we would like to request for that too. Thank you, Your Honor. And he also has a job he's gainfully employed at Waffle House. So he really got to get out and go back to work, Your Honor.
What?
Pre-trial, is he recommended?
Yes.
That'd be SOB jail.
Yeah, I don't
Yes.
have that.
Well, I was gonna leave this one to your discretion.
And Your Honor, since I'm recommending a stay away in this case, I would just like to confirm that the place of employment is not the same location I'm asking the court to issue him to stay away from. So is it that Waffle House at the incident location? Because that's the same place that this incident took place, or is it a different Waffle House?
Yeah, please ask my client really quick. Mr. Moran, would you please answer?
No, ma'am.
Is it the same one?
No, ma'am.
Okay, no, ma'am.
Where did the incident alleged to have taken place, Mr. Moran Hickey?
You said what?
Where did this incident take place?
Johns Creek.
And you work at which location?
5565 Beaver Highway, North Georgia.
Okay. So you work at the one on Beaufort Highway. Okay. All right. So I'm going to order a $1,500 surety bond.
You mean signature on bond, Your Honor?
I'm sorry?
Signature on bond, Your Honor? He's recommended, Your Honor.
It's gonna be a $1,500 signature bond through the jail.
Thank you, Your Honor.
Okay.
And it is a stay away from the incident location, which is 9650 Medlock Bridge Road. And I'm going to order no further violent contact with any Waffle House employees. No drugs, alcohol, or weapons while on bond. And that should be it for this case.
Thank you, Your Honor.
Uh-huh.
Thank you, ma'am.
Thank you.
Position 10, Milchester.
Me?
Yeah.
Oh, Michelle.
I think she said she. Yeah, she was about to do that.
Yeah.
All right, this is 22 CR 003862Y.
Oh, I'm sorry, Judge, going back, was that an SOB through the jail for the last position that we just had? Because you said surety bond and then you switched it to SOB jail, is that correct?
Right, I switched it to SOB jail, yes.
Okay.
All right, this is Christine, is it Moschetta?
Yes, ma'am.
You're charged with 1 count of battery family violence. The offense date is June 16, 2022. Pre-trial?
6 total. He don't have any violence, just a bunch of drug charges. Last arrest was June. Hold on. Where are they put on here? Yeah, last arrest was 2007.
Okay.
Possession of a controlled substance. This was out of Florida. All this history come out of Florida.
Okay. All right, Ms. Harmon?
Yes, Your Honor. The incident location is 555 Grimes Place in Roswell, Georgia. And the victim in the case is Bettina Borchata. It's Bettina, last name Borchetta, Borchetta. Your Honor, the parties are sisters and they do live together. Officers were dispatched on a call regarding a physical altercation between the parties. The defendant states that Ms. Borchetta was intoxicated and she had become violent on their way home from a concert. She stated that the victim punched her while she was driving. She pulled over and let the victim out of the vehicle, and then she went on and continued on home. And when Ms. Bettina arrived back at their home, she locked herself in a room with their mother to have a conversation about what occurred in the car. She told the officers she wanted to kind of discuss that privately with her mom. She said at that point, the defendant began banging on the door irately, demanding to be let in. And so when she opened the door, another physical altercation between the parties began. The defendant did sustain a cut on her finger. The victim, however, in the case, had an obvious injury to her forehead, quote from the report, and her face was, quote, mostly covered in blood. Bettina did indicate to the officer that the defendant did strike her when she opened the bedroom door. The defendant did admit to officers that she swung at her sister, but she didn't realize that she hit her and that her punches connected. Your Honor, we obviously believe that this defendant is a danger to the victim, and that's clearly based on the incident details. She doesn't have a lot of history, but this is a concerning incident because this is family violence. And it was kind of unprovoked at the time. It had already been, the victim was already talking to the mother, and the defendant demanded to come in the door and started an altercation at that point. So that is concerning. In light of the foregoing, Your Honor, we're recommending a $2,500 surety bond, no further contact with the victim in the case, Bettina Borchata. Stay away from the incident location, a 1-day anger awareness, no alcohol, drugs, or weapons, nothing further.
All right, Ms. Kim?
Yes, Your Honor. Actually, right now, I have been trying to give the Zoom link to Ms. Tina, who wants to join us to tell the court that she wants her to come home. Anyway, Ms. Christine is 61 years old, and Your Honor, her story, this is the reality of her story. She was the one who was driving the car with a sister who was drunken. And because her sister was drunken and started attacking her while she was driving, she had to be she wanted to make sure that she was safe with her sister and her mom, and she was not the first aggressor. And that's the main point that we would like to address here. And my client says she does not do any kind of drinking, and her sister was the one who was drunken and hit somewhere, probably a furniture or something, and she had all this blood. My client says she never had any contact with her. So there's a huge misunderstanding here. And Your Honor, right now, she has been here in Georgia for 12 years, and she has her mother, sister, and sister's children, and they all live together. And she has been working at the same place for about 4 years. Prior to that, same company for about 8 years. She completed her high school degree, and she has a strong ties to the community. She does not have any flight risk, and I believe that she is qualified for signature on bond, Your Honor. Thank you.
All right.
Your Honor, has to be.
Please, Miss Christine, I would like to recommend you to stay silent. If you have any question, I'll call you.
All right. I'm going to order a $2,500 signature bond through pretrial. I'm going to order the one-day anger awareness course. I'm going to order a stay away from 555 Grimes Place. I'm going to order no further contact with the victim, Patina Brochetta. No drugs, alcohol, or weapons while on bond. And I think that will be everything.
Your Honor, may I please double check the incident location? I just want to make sure that is not the duplex that they live together. I thought I wrote down the address. Is it?
That is the same address, yeah.
Oh, okay. Your Honor, may we please have remove the stay away? It's okay not to contact her sister, but stay away. That's the place where she resides with her mother. It is a duplex, and her sister can stay in the other part of the duplex, Your Honor, but she has to go home and take care of her 89 years old mother, Your Honor.
Is that true, Ms. Machetta? Is it a duplex?
Yes, ma'am.
Do you stay on one side and or you stay on the side with your mother, or can you while your sister stays on the other side?
If I have to, my niece, my niece lives on the other side with her husband and her 2 kids.
Okay, you're gonna have to do that, because if you have any more violent contact with your sister, you're coming back to jail.
Okay.
All right, so I'm gonna remove the stay away because it's a duplex. I'm gonna order that you stay on the side without your sister.
Okay.
Thank you, Your Honor. I appreciate it, Your Honor.
Uh-huh.
So there's no violent contact?
Right, no further violent contact.
We're completed here in courtroom 2.
All right, thank you.
Thank you.
Thank you, Your Honor.
Hey, number 1 was released.
Okay. What about number 3?
South Annex.
Right, can you hear me, South Annex? Okay, this is case number 22 CR 003866C, Jamesia Jeter. You're charged with 1 count of battery family violence. The offense date is February 23rd, 2022, pretrial.
It's a first arrest. She was recommended. So there's a TPO. She's the victim in the TPO with Anthony Hendricks. The TPO was issued back in April, and it expires next month. It says a 3-month protective order.
Okay,
That's all.
all right, thank you. All right, Ms. Brown.
Yes, Judge. In reference to that TPO was actually issued after this incident happened. So what happened is this incident happened back in February, February 23rd of 2022. The two of them, Ms. Jeter and the victim in this case, there was already an order in place regarding visitation, and they were meeting at 2353 Metropolitan Parkway to for him to get his child or return the child. So there was always already an order in place for them to meet at another location. So they're out there, he's out there meeting regarding his child. She shows up with another young man, arguably her boyfriend, and she tells him to jump on or to attack Mr. Hendricks. And in the midst of that happening, Mr. Hendricks tells them, to leave him alone, to go on. He doesn't want any trouble. He just wants to exchange his child. The two of them attack him. The unknown male, along with Mrs. Jeter, attack him. Mr. Hendricks then goes to the police department and reports it to the police. And the police officer, once he makes a report, observes that he has a swollen right eye. He has visible marks and bruises over his face and his arms. After that happens, instead of turning herself in, Ms. Jeter goes and files for a TPO when she's made aware of the fact that she had a warrant. So this happened on the 23rd, and then she went and filed for a TPO in April. And I believe that TPO may have been handled by Zoom. Mr. Hendricks indicated to the officer that this was not the first time this had happened. It had happened before, I believe, at her mother's house, in terms of Ms. Jeter using another young man to attack Mr. Hendricks. And he didn't report it that time. But this time he decided enough was enough. He went in and he reported it to the police. And again, there were marks and bruises that the officer was able to observe. Based on that, Judge, we are asking for $3,500 surety bond, and no further contact with Mr. Hendricks, no alcohol, drugs, or weapons. Judge, I know that she qualifies technically for a signature bond, but I would ask in this case that you not issue a signature bond, primarily because, one, she's a flight risk. At the time that the incident happened, the fire department had to come out and break up the incident. They had to get the two of them off of Mr. Hendricks. And upon doing that, Ms. Jeter and the young man that attacked him fled the scene. So that's in part why this happened in February, and she's just now being arrested on it. So they fled the scene. Mr. Hendricks had previously indicated to the officer that this happened before. So not only is she's a risk to reoffend, but she's also a risk to try to intimidate or influence him. And she's already done so by filing a TPO against him after the fact, after this in fact happened. So we were asked in this case for a $3,500 surety, Judge.
All right, do we know how many children are the ages?
This child, it was one child. I can look that up. Judge, give me a second.
Do you know Ms. Hogue at all?
I know there's one child, I believe is 2 years old right now, and that is what they share.
Okay. All right, go ahead, Ms. Hogue.
Yes, Your Honor. Ms. Jeter is 25 years old. She is born and raised here in Georgia. She has significant family ties here, including a father, her own son, and of course, she's now currently pregnant herself. I couldn't quite follow when the TPO was being requested. It sounded like the TPO that she requested was sometime in April. Is that correct?
I think that's what I heard from the state, yes. That it was in
yes, Your
April,
Honor.
3 months.
Yes, just to let you know that she is a high school graduate from Booker T. Washington. She did go to trade school for dentists, to like dental hygienist. However, she's not been able to finish because of the birth of her child and trying to take care of that child, Your Honor. She does live with her mom and does help to also support her mom as well as take care of her child, and is currently pregnant. As far as work goes, she's been doing temporary work through an automation temp agency, doing mainly warehouse work where she has temporary jobs working in warehouses. So her finances are spotty at best. As far as everything goes here, what I'm hearing about right now is an incident in February, okay, of 2023. upon which she was not arrested at that time. And apparently Mr. Hendricks went at a different time to take out a warrant. While there was some there, I guess, splitting them apart, no one, I guess, bothered to call the police. He went down at a later time to take out a warrant, which I doubt she even knew was taken out. Apparently, according to them, she takes out something 2 months later in April, and somehow is a flight risk because she's not aware of a warrant that was taken out on her and is now finding out possibly about this warrant, we're told, in April. So at this point, I would say it's very questionable. Also, the tension between these two is not just one way. I do believe it is two ways, with both parties being able to make allegations against each other. She didn't run out and take this TPO out. It was 2 months after this particular incident based on other issues. I do understand that there is either a legitimation that has been completed or is in the process with an agreement. I have discussed with her the fact that she must follow that agreement, which I believe is a drop off at zone 6, where then I believe his mother comes and picks up the child or the child's grandmother. Your Honor, she has no history whatsoever. This does appear to be contention between the two. I do believe that as long as the legitimation, court-ordered, scheduled custody is followed, there should be no problems between them. So I do believe that she should be granted her surety, her signature bond, Your Honor, with the fact that they must follow the court-required transfer of the child that involves neither of them meeting each other. That is what we request today.
Judge, if I may.
Let me ask one other question. So is this, I have the offense date is 2022 or is it 2023?
Pardon me, it's 2022, but it happened on February 23rd in 2022.
Okay,
Is my
2022.
understanding.
Okay.
Yeah, so it's 4 months ago. She took out a TPO 2 months later with other issues involved, Your Honor. As I can say, these two apparently do have issues with each other coming from both sides.
All right, I see someone on the screen as Candace Hendricks. Ma'am, are you involved in this case?
Yes, Anthony is my son, and I think he is on the Zoom as well.
Okay, hold on 1 second, because I'm going to have to swear you in if you're going to speak to the court. Do I have another person on Zoom? Anthony Hendricks? Can you hear me, Mr. Hendricks? Looks like he may not have a good connection wherever he is. I'll go ahead with you, Ms. Hendricks. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
Okay. And again, tell me your relation and how you're involved in this case.
Anthony Hendricks is my son. Ashton Hendricks is my grandson. And when this altercation occurred, Ms. Jeter had came to me the Saturday, the day before the incident. She came, I think it was 2 days before the incident. And she told us that she needed me to keep the baby because she was displaced at the time and where she was staying at was unsafe. So we had the baby. She was upset because my son was off and he kept the baby that day. I was concerned about him going to drop the baby off because she called irate, bring me my child, I want him right now. She was acting very ugly. I had a feeling that something was going to happen. So I called the fire station to alert them that the baby there was going to be an exchange and it may be an altercation.
And let me stop you real quick and ask a question. So with what you understood for the visitation for your son, Mr. Hendricks, was he supposed to have visitation or not?
Our weekend was the weekend before. She called to bring us the baby. She voluntarily brought us the baby.
But was the baby supposed to be with him or with you?
The baby was with us. I mean, he lives at my house.
So he was granted visitation with his child and you were assisting?
Yes.
Okay, that's what I wanted to make sure of, that he did not have some type of order that stated he was not supposed to have his child.
No.
Okay. And this was an additional weekend visit?
Yes.
Okay, all right.
And then the altercation happened.
But you were not there. You were not
I was
there, is
not-
that correct?
I was not there.
I don't
But,
want you to tell me anything much about the altercation because you were not there, because you would be basing it on what you've heard. And I will hear from Mr. Hendricks if he wants to tell me what occurred at the altercation. So after you found out or thought something was happening, you sent the fire department there. And then what was your next interaction? You saw your son later, I'm assuming?
yeah, I didn't see him until later, after he had went to the police. I didn't see him until after, because I was at work when the incident occurred.
Okay, did he have any injuries on him that you noted?
Yes, he had bruise on his face. He had scratches everywhere. They had torn his clothes off. He had bruises on his upper torso.
Okay, all right. And Mr. Hendricks? Can you hear me now? Yes. Do you want to address the court today?
Sure.
Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. Can you tell me briefly what happened on that date?
I had my son during the week, which I work. Most of the time I work, since I only have visitation rights for the weekend, I never really get to see him on Sundays. So I decided, since I'm off, I was like, you know what, he got to go back home. I'm gonna just go ahead and spend that time with him today before I got to take him back. So once she found out, like, I posted a video basically on social media, me and Ashley sitting down, we was eating McDonald's and watching cartoons. She became irate. Like, she was texting me and constantly, it was like trying to start an argument basically. So about probably, I'd say like 1 or 2 in the afternoon, I had Ashley sitting on top of the dryer because, it was just me and him at the house. And I was
how old
showing
is
him.
your son?
He's 1. And I had him sitting there because I was putting clothes in the washing machine, so I didn't leave him unattended. And I was like, well, it could be something. He watching me do it. I got to teach him how to do it anyway. So in the midst of her calling me, I'm showing her what I'm doing with him or whatnot. That didn't matter to her. She was bringing him to me and this, that, and the third. So I called my mom and let her know what was going on. She was like, just take him, because she's irate. She's trying to argue and all this stuff. So just take him so it won't be a problem. Okay, upon arriving, it's just me and Ashley. Mind you, I've been letting my mama handle him, transport him back and forth. And me and Miss Jeter, because I know it's gonna be a problem. Like, she's the one who wanted me to make the transaction, saying it shouldn't be your mom. You need to do it. You his dad, and this, that, and third. So I was like, okay. So I go to drop him off. They are already sitting there. Her and her boyfriend is already at the Cleveland Avenue fire station. So as I pull in, she's already getting out the car, walking toward my car. I hadn't even stopped yet. So I was like, oh, nah, I see a camera. I'm going to pull in front of the camera, because the week of Valentine's, she had just swung on me in front of her mama's house, and I didn't have nobody with me. I didn't have no camera out there, nothing. It was her and her boyfriend. So I was like, this time, if she try to act crazy, it's going to be caught on camera. It's a camera right there. So I'm telling her, I'm like, look, just stand where you at. I'm going to walk him over there to you, because what you did in front of your mama's house, like, I don't want you near my car. I don't even want you approaching me, because I pulled up in my girlfriend's car in front of her mother's house, and she threatened that she'll, not only do something to me, but I kick your girlfriend, I bust her windows out, I do this, that, and the third. And now my girlfriend is not present. I'm just there by myself. So when it came to her approaching my car, I was like, nah, just stand back where you at. I'm gonna walk him over there to you. In the midst of doing that, she turned around and told her boyfriend, she called his name, told him, come beat his ass. So I was like, now see what you're doing. Like, you causing something that don't have to be, and there's a camera right there. She didn't care, they didn't care. He just walked up, like, just, of course, on her side, ready to fight. And I was telling him, I was like, look, I'm not even trying to be physical with her. Look at what she's standing at versus where I'm at. I'm not even touching her.
Did anyone from the fire station come out?
No, they didn't come out until the fight had already, like, we had already got to fight and whatnot by the time they came out.
Okay, so this other person who you believe is the boyfriend to Miss Jeter jumped on you and started fighting, beating you up.
Right, he put his hands on me first.
Okay,
Like,
are you in fear? Okay, hold on, because I don't have a whole lot of time, but are you in fear of Miss Jeter and her boyfriend at this point?
Yeah, because it's like it's unpredictable about what they'll do. And I know if I do something or whatnot, I'll be the first one blamed to lose my rights. That's why I was trying to handle it this way.
Okay, so after this incident happened in February, when is the last time that you have visited with your son?
His birthday, he just recently turned 2 in April, and we threw him a party for his second birthday. And after that, I hadn't seen him since then.
Okay, since April. Okay. All right. And do you have a visitation order in place?
Correct.
Okay, and that's from the Superior Court from Fulton County?
Correct. Well, when this incident on February 23rd happened, my paperwork that I put in was actually to modify that to get more time with him because of how she was acting and whatnot. So when she took hers out, it was to retaliate against that. That's why her dates and stuff is wrong, because mine was never to do anything out of spite. It was just for my protection to, to keep what I got and whatnot, because I'm not even trying to be arguing or fighting with her. Like, that's not what I want to do.
Right. So your order that you have in place now is for legitimation and visitation. Is that correct?
Correct.
Okay. All right.
Your Honor, excuse me, I'm sorry to interrupt, but the baby has already been legitimized. They did that the first time when they went to court and he got the visitation and all of that. The legitimation was complete then.
Okay, I understand. So this was a modification of the visitation.
Correct.
But there is an order in place that they should go by.
And she's supposed to meet me to exchange the baby, but she refused to do that. She won't meet me. I'm sitting up there, and she won't come and bring him. We don't know where he is. We haven't seen him.
Okay. Well, you'll have to take her back to court for that if he hasn't seen his child per the order. I can't do anything about that, but I'm not going to grant her a signature bond just because of the conduct that I'm hearing. And I appreciate you all for getting on and spending your time to bring me up to date. I'm going to grant a $3,500 surety bond. And with that surety bond, I'm going to order that there be no further violent contact with Mr. Anthony Hendricks. Or Mr. Hendricks, do you want her to stay away altogether? Or do you just want no further violent contact with you?
I say just stay away altogether, because I've been letting my mom handle speaking with her, and the exchange is for that reason.
Okay, well, I'm going to change that to have no further contact with you while she's on bond. I'm going to, I don't think, do you want a stay away? Does there need to be a stay away from any location? I'm inclined to say no, but you tell me what would make you feel safe.
Well, as far as I know, she's not allowed around my house, but other than that, I guess if we could change what we pick the location of the drop off to ensure that my mom is okay or whatnot, because I'm not there when the drop offs happen.
Well, the problem is I cannot change your Superior Court order for those things. You will have to go back to Superior Court and file the proper actions, contempt, or whatever you need to file, and maybe get an attorney as well to help you with modifying it or going forward since you've had these incidents. And so what I'm going to do is no further contact with her. So that means you cannot contact her. She cannot contact you because she would be violating the terms of the bond. So if there's going to be any exchange of the child in the interim while she's on bond, or if she makes bond, then that exchange person, I'm wondering if I put your mother in that situation or not. Is there any other person that can do it? I don't want to put anyone in harm's way, but I'm trying to provide an avenue, a safe avenue for you to see your child.
Excuse me, Your Honor, I don't mean to interrupt you, but I have a problem here in that she has no violent history, Your Honor. This is all coming from them. Even on his own admission, the fire department didn't arrive till after the altercation had started. So we don't know exactly how this altercation started. that will come out. I do believe
Okay.
they have an order upon which Ms. Hendricks is supposed to be picking up the child, which as long as they conform with that, I don't see a problem with that. I don't see a
But I was
problem with
gonna
no
use her
contact.
as, right, I was gonna use her as a third party, but I just want to make sure everyone's safe. Ms. Hendricks, are you okay still being that third party to be the exchange person? You're on mute. You're on mute. Unmute yourself.
Yes,
Okay.
I don't have a problem with that, but she does have a history of the violence. We went through it at the TPO. She even damaged my car, jumped on my car. Like, we have a lot of stuff. It's just that
Okay.
it's not, we don't have to handle that today. But
Okay.
my
I'm
concern is,
not here for that today. My question is, are you okay if I put in this bond order while she's on
yes,
bond with this case that you, and tell me your first name?
Candace, Kandis.
Candace. That Miss Candace Hendricks, who is the mother to the victim, will be the exchange person for visitation going forward, unless there's some other orders by the court. And again, Ms. Jeter, there should be no further contact between you and the victim, Mr. Anthony Hendricks. The exchange of visitation allowed with your son should go through third party of his mother, Candace Hendricks. I'm going to also order no drugs, alcohol, or weapons while you're on bond. I'm going to order you to take the 1-day anger awareness course. And I hope that you all can get to a place where things go much more smoothly for you and raise your son with some co-parenting. Okay?
Your Honor, as I said, I do believe that a signature bond is warranted here. I understand these allegations, but they're unsubstantiated. She has no charges but this, and it's coming from the father and a biased party of the mother. Okay, I imagine there's allegations on both sides. I have no problem with the stayaways, neither the she, the contacts, the exchanges, but she is a single mother, limited income, and she has no history other than whatever allegations are between these two people who I'm sure Miss Candace Hendricks is very lovely, but she has a bias for her son as well. And like I said, that can be taken up at other times. And if more charges are ever alleged and come up in a criminal matter, that's fine. But at this point, she has no history other than whether they are claiming between themselves.
I understand. And I do want to make sure that the victim is safe. And he stated that he is not safe and doesn't feel safe. There's, I guess there's been some cooling off, but I don't know, because afterwards, then we had the TPO. He says he's not seen his child since April. And I do want to make sure going forward that my victim here is going to be safe.
I believe he will be safe, Your Honor. And I don't think, like I said, these are unsubstantiated allegations between people who have contentions. Okay. And she has no other history other than this. Okay, Your Honor. And they can certainly take all these matters up. They apparently have nothing has come forward as a criminal charge against her other than what is before us now, which is 4 months old. Whatever their issues are, they certainly can work them out. And if there are issues that arise again, then certainly she can be brought back to court on other criminal charges if in fact they have actually happened. And certainly then a different kind of bond could be arranged. But I do believe a signature bond with all the other stay away conditions is warranted in this case.
State, do you have anything to add? I was getting ready to ask, do you have anything to add, State?
Yes, Judge, I would just say this just briefly. I think it's important to know, in addition to what the victim has said, it's very clear from the warrant that the day that this happened, he went into the police department that very day. That's what the warrant says, and spoke to police about what had happened. And we find ourselves with her being arrested in June. Arguably, defense can say she didn't know about the warrant. I find that highly unlikely, given that a TPO was filed in April. You heard the victim say they had a party for him in April, the earlier part of April, and then later in April, there's a TPO filed against him, which I suspect has something to do with why he hasn't seen his son. I think it's easier to believe that this is retaliation. There's no information about anything having happened before. I understand that she doesn't have any history, but it is believable that they reached out to him to return the child. He returned the child. She appeared with somebody in tow to start an issue with him. And so based on that, Judge, I understand she doesn't have a history, but not having a history is not the only consideration for bond. The other things to consider would be, as you've stated, protecting your victim, protecting the victim in this case and making sure he feels safe. And she is at risk to intimidate or try to influence him or try to keep him away from his son at this point. And again, I would say that she ran away from the scene at the time. And between February and now, she has made no attempts to handle or resolve this matter. Contact the police, find out she had a warrant, turn herself in, resolve this issue. So she's not really a good candidate for a signature bond. So I ask that you keep the previous ruling in place and hold this as a surety bond.
Your Honor, I disagree. As I said, the fact that she supposedly found out in April, we don't really know. Okay, whatever his problem with her visitations, and if he has a legitimate court order, he can take all that up through the courts. Okay,
which
she's
is
not
what I
intimidating him.
Yeah, that's what I said. One last thing, and then I'll be done, Mr. Hendricks. Tell me.
I was gonna say that's not true. Ms. Jeter did know she had a warrant for her arrest, because when it was granted, when the judge for her case granted that protective order, they said it to her then. They announced it over the Zoom call that she had one out for her arrest. They notified her then. We was trying to get the information to her. She said, that's not my email no more. The judge even told her, they said, Ms. Jeter, it's up to you to get the information for what we're trying to tell you what's going on now. So we was trying to send her all the paperwork as to what we was trying to go to court for to modify what's already in place. She wanted to, after that, after I already went, she knew I went down to the police precinct and filled out my paperwork, which is why she went after. That's why she.
Well, I know that this is more of a civil matter relating to your visitation and your after your legitimation case, and I hope that things will begin to cool down and get better. For the moment today, I'm going to stick with the surety bond of $3,500 and the conditions of no further contact with you. If she allows visitation with your son, or if that is to still happen, that your mother, Candace Hendricks, will be the third party to exchange the child for visitation. And hopefully you will be allowed to do that. Going to order no drugs, alcohol, or weapons while on bond, and a one-day anger awareness course. All right.
Yeah, Honor, just one last thing. It's our weekend and we don't know where he is. Now she's saying she lives with her mom, but that her mom is saying she doesn't live there. When the sheriff went to serve her, they said she didn't live there. And that's why we haven't seen the baby. And I'm saying it's
but you're gonna have to take all of that back to the civil court. That is in the family division, I guess, if you're in Fulton County. That those kind of issues and contempt matters and things of that nature are going to have to come back through the civil court. I cannot change or do anything about that. You will have to take her back to court for those violations or things that are not happening. And like I state, if you all do visitation right now while she's on bond for this battery family violence charge, then you will be the facilitator. If you don't feel safe and can't do that, you can get a copy of the bond order, show that to the sheriff and try to see if they can assist. But if not, you're gonna have to take it back through the family division to get any changes or other things with the visitation order, because I cannot do any other modifications to it at this time in this court. Okay, so be safe and good luck to you all. Thank you. All right, anything else? I think that was our last case.
Nothing from the state on this one, Judge.
Okay. Are we ready to reconcile?
Yes, ma'am. Position number 1 was released. Position number 2 is $1,000 sign-on bond through jail. Position number 3 is a $3,500 good bond. Position number 4, $3,500 good bond. Position number 5, $2,500 good bond. Position number 6, $2,000 good bond. Position number 7, $1,500 good bond. Position number 8, $4,000 good bond. Position number 9, $1,500 sign-on bond through jail. Position number 10, $2,500 pretrial bond. Position number 11 is a $10,000 good bond.
Okay. Anything else? Any other corrections or anything from anyone? All right, everyone, enjoy your weekend. Thank you so much.
Have a good
Thank you,
weekend. Bye, Judge. Bye, everybody.
Bye-bye.
Judge, I'm sending them over now.
Thank you, dear. Appreciate it.
No problem.